Everybody, welcome to this issue of Staffing Monthly, where we are going to take a deep dive into one of the legal issues that is really impacting our industry. And I know that many people are on either side of this issue. Some say it's a great thing, some say it's not a great thing. And we're going to dig into that a little bit, wade into those controversial waters. But I actually have somebody that has been a friend and a legal representative for a number of years. We actually met through the National Independent Staffing Association, but his name is Evan Rosen. He's with Jackson Lewis, and they are a nationwide law firm that has, I get practices or offices in every single state, seemingly. And I was going to tell you a little bit about his firm in a second, but I've known them because they're an employer side attorney, and they really work with companies in Evan's area. They really work with staffing companies to defend against discrimination suits and claims and all of the stuff that every one of us out there is just terrified of. And we're doing all the things compliantly to make sure we prevent them. But that's the world that he lives in. And I'm actually inviting him in to talk specifically about the pay transparency laws that are hitting our industry right now. But Evan, before we jump into that, first, thank you for being here. But could you share just a little bit about Jackson Lewis, your practice, and really what your focus is for the folks that are listening here?
Sure. Thanks for having me. So I am an equity principal at Jackson Lewis. We, as you mentioned, only practice labor and employment law. That is our expertise. That's our specialty. We are in 61 cities across the country. We also have an international alliance. We have roughly 1,000 lawyers, all of whom practice labor and employment. But within labor and employment, we all have different specialties. So for example, we have folks that just do wage and hour law all day long. We have folks that deal with federal contractors and all of the related issues there. We have folks that just do ADA and FMLA, data privacy, restrictive covenants and non-competes, immigration, OSHA, employee benefits, and of course, litigation, traditional labor. So pretty much anything within workplace law, we handle and represent exclusively management. Within that, we do have industry focuses as well. And so one of the most significant industries that I'm involved in and always have been is the staffing industry. And I'm one of the leading members of our team here in that industry. I come by it naturally, I like to say. So I worked through college, having worked at staffing companies doing light industrial and clerical work. And then once I became a lawyer, I actually was at a huge New York City law firm, and I would manage a group of about 30 temporary legal employees. And then when I moved to Atlanta 13 years ago, the former general counsel of a big staffing company was a partner and got me involved with the Georgia Staffing Association. And ever since then, for the last 13 years, and I've been involved with the Georgia Staffing Association. Last 10, I've been on the board of directors, and certainly gotten to know you and many others through the American Staffing Association and through NISA as well. So I like to say I come by the staffing industry naturally, and I'm really proud to represent staffing companies throughout the whole country.
That's honestly, man, as long as I'm doing it, I had no idea that you actually started out as basically a consumer of staffing, if you will, or basically being a temp working LI. And like, that's amazing. I knew that you would manage we talked about that in New York City, that you would manage some of the legal space or the legal contractors, but I had no idea that you actually were a worker for an agency at some point.
Yeah, absolutely. That's on winter breaks and summer breaks throughout college. That's what I did to, I don't know if on this program I could say it was beer money, but let's just say it was social money.
Social money, social money. Hey, we're a come as you are type audience, so we're good. Well, that's fun. I know that, and I mentioned this to you, but for those listening, everyone that's ever attended one of your sessions at the National Independent Staffing Association always gave you rave reviews. When we were just rebooting this past conference, and I was asking the members like, hey, give me recommendations of people that you remember that you want me to invite back. Your name was at the top of the list there, which is why I reached out, which is I know it was short notice. I was disappointed we couldn't put it together for the timing, but we'll keep you plugged in the future, because everyone loves what you share because it's practical advice, and that's why I wanted you to talk about this, like the pay transparency law. Like, I think there's some confusion about it. Most people are concerned about it. So like, what does it really mean? Like, what is the law? What's going on? What do staffing agencies really need to be knowing about and doing?
Yeah, so I think in order to understand pay transparency, a little bit of history, I think, is helpful before we get into the most recent laws. And this idea of pay transparency really cannot be considered on an island without also considering some of the equal pay legislation. or what we sometimes refer to as pay equity laws. And the first one was actually the Equal Pay Act in 1963. That's one of the few federal laws that's actually on the books in this area. And what that law did is it requires that men and women receive equal pay for substantially equal work. And it came as an outgrowth of World War II, where a lot of women were in the workforce while the men were fighting overseas. The men come back, they take a lot of the women's jobs, and or the women's pay gets suppressed. And so men were, the statistics show that men were earning somewhere in the neighborhood of 40% more than women for the same work. And so this law was designed to cut into that and to have equal pay for equal work. Then the National Labor Relations Board, which most people think only applies to union settings, but it doesn't. It applies to union and non-union.
Yeah.
There's a part of that law that's referred to as Section 7, which is, I'm not going to bore you too much with legal mumbo jumbo, but it's essentially protected concerted activity, which in plain English means employees have the right to act together for purposes of trying to improve their wages, hours, and working conditions. And as part of that, the Labor Board has said for 50 years now that employees have the legal right to discuss wages at work. So you can't tell employees that their wage rate must remain confidential. The one caveat to that is the National Labor Relations Act does not apply to supervisors. Okay, so then from there, starting much more recently in around 2016, you had states start to pass salary history bans. So this was these were laws that you may be familiar with. Some states and cities that said, look, in the interview process, in the application process, in the hiring process, you, number one, can't ask about an employee's current or prior salary. And number two, you can't make a decision based on it. And it was for the same reason. It was this idea that women are paid less than men for the same work. And so if you're making a decision based on a woman's prior salary, that discrimination potentially could continue to occur throughout into the future. And so the idea was to stop that. And these state laws were important because unlike the National Labor Relations Act, which does not apply to supervisors, this does apply to supervisors. And the other reason these laws were important from a very technical legal perspective is I mentioned the Equal Pay Act. Under the Equal Pay Act, you're allowed to have a differentiator. You're allowed to pay men and women separately if you have, there's essentially four exceptions. If it's based on their seniority, if it's based on merit, if it's based on some sort of incentive or production system, or if it's based on a factor other than sex. And that's where all the litigation is. And there is a circuit split as to whether making a decision based on somebody's prior salary is a factor other than sex. Some circuit courts say yes, some say no. So a lot of the state courts, a lot of the state legislatures and local legislators said, well, we're going to decide for ourselves that you can't ask about salary history. And so that was the impetus for these laws. And then to get finally to your question, lawyers do have a tendency to talk too much, Dan. But to get to your question, more recently, within the last 2 years, a number of states and cities have started to pass what's called pay transparency laws, which goes a further step. And these laws generally require that in any kind of job advertisement, usually not only for an external candidate, but even if it's for an internal promotion or transfer, that you have to include compensation ranges on your job advertisement for each position. So that's essentially, there's a lot of nuance depending on which law we're talking about. Not every state or city has them, but that's essentially what those laws require, is to include some sort of compensation data on the job advertisement. And it could vary as to, is it just wage rate and salary? Does it include benefits information? And we can get into that, but that's essentially what it requires.
So one, I love the history lesson because there was some stuff in there that I wasn't brushed up on, and it actually makes sense, which leads to a question I'm going to keep in the back of my mind, and hopefully we can get to that might be muddy the waters for the future. But with this, I've seen things out there on the internet, and it's a bit meme-ish, if you will, but like Netflix hiring for people where they'll say, hey, we're paying someone from like $10,000 to $800,000. And like, that's their wage range. So like obviously, in my opinion, that's a little bit ridiculous, but like, what are there parameters? Are there any sort of guidelines that the employer should be following within the ranges that they should be posting?
So, as defense counsel, I'm going to tell you it's absolutely not ridiculous, Dan. No. um, More seriously, the general standard is that it has to be reasonable and in good faith, that's grounded in reality, right? It can't just be completely fake. It has to be somewhat grounded in reality. And you need to think about not only what, how you're going to come up with these ranges, but also how it's going to potentially lead to litigation and or create employee relations concerns. Because let's assume, for argument's sake, that you are hiring for a corporate employee that's a recruiter. And let's assume you put the salary range as $30,000 to $60,000. Okay. Well, what happens if you have a recruiter right now that's at 29,000? They're gonna be like, what the hell? I'm not in that range. Or let's change it. What if they're at 33? They might say to themselves, who's at 60? Right? I'm at 33. Who's making $60,000 doing my job? And why isn't it me? Right? So
it's a valid question, though. I get it.
So that's going to create employee relations concerns. And then from a legal perspective, the bigger the range, the more potential there is to have disparate treatment. What if only certain groups are at the lower range and different groups are at the higher range? And this becomes potentially concerning in the staffing industry, in particular with your field employees, when a lot of times the rates are going to be dictated in part by your contract with the client. And although we certainly fight hard as an industry to stop this, we do know that sometimes there are clients out there that are not as ethical and legally compliant as we'd like, and they sometimes do have preferences, whether it's obvious or more subtle, based on race, based on sex. And if those are the higher priced clients, and I'm not saying they aren't, but if they are, does that then create a risk for the staffing company where we're essentially discriminating on the basis of sex or race or some protected category, not because we're intending to do it, but because if our higher priced clients are the ones that are
Having those tendencies.
having those kind of preferences, that they shouldn't. So those are some of the things to watch out for.
So let me, just for my own clarity and understanding, let me run through a scenario. Let's say it's a fairly national light industrial staffing. Actually, let's go regional. Let's go, it's regional, light industrial staffing agency. And let's say that they're in kind of the Midwest, South, of the United States. Well, kind of your Texas, your Oklahoma, like that area, right? So the big regional footprint, but it's just regional there. And they're light industrial. That's all they do. And when they're recruiting, they're always recruiting for light industrial workers. So those workers could earn anywhere from, we'll say the lowest minimum wage, which I don't know what that is off the top of my head. Let's just say it's, $9.50 an hour for some reason. And then all the way up to the highest material handler or logistics operations person that's not a supervisor in this scenario, and making, we'll say, $24 an hour, right? Like that's the range within there. If just by the nature of a diverse client makeup, you actually have like one ethnic group, gender group, some classification that happens to be in that, let's say, $22 to $24 range, and then you have a different ethnic or gender group that happens to be in that $9.50 to $10.50 range, like if it creates that sort of separation, like is there any, like, the agency's not doing anything wrong, they're just meeting the needs of their clients, but does that present any legal issue, or am I?
Yeah, there's some risk there. I mean, and it's why one of the things that we recommend is doing a pay equity audit, so that you can identify whether there's a risk. I mean, it should be that there are some clients that are lower paying, and that is across races, sexes, and ages, and there's clients that are higher paying, and that's across races, ages, and sexes. But if it's, to use an example, all the Black and Hispanic women are paid at the $9.50 rate, and all the Caucasian men are paid at the $24 range, then you have to have a good legitimate, non-discriminatory reason for that. And the question arises whether your staffing agreements and with your client, whether that is a factor other than sex that would give you a defense under the Equal Pay Act and related legislation. We would argue it is. We would argue it is a defense, but I could also see a plaintiff's lawyer taking a different position on that. And these pay transparency laws in particular are pretty new, so we don't know how it's going to get litigated, but that's one of the risks that I see. And I think as long as it's a good faith negotiation and that it's a real contract and that there's not evidence of client preferences for a particular race or something like that, then I think it's a good defense. But again, I could see a plaintiff's lawyer taking a different position. The other thing I'll say about your example, just for the audience, Texas, Oklahoma, most of the areas in sort of the South Midwest do not have these pay transparency laws, at least not yet. There are the pay equity law, again, as a federal law, the National Labor Relations Act is federal law, but most of these salary history bans and pay transparency laws are not in the South yet. There are some places in the Midwest, for example, Cincinnati and Toledo, Ohio, both have laws. Michigan is about to have one. South Carolina is considering one. And there's new ones being passed all the time. But in the South, East, and Midwest, there's not that many just yet.
Okay, so that's fair. Now, if you're that agency and you get pulled into this and you say, hey, no, here's my client, here's the recs they give me, here's the candidates that we screen and we submit the candidates to them and they choose who they hire, and then here's over here on this end, like, is that a good enough defense just to show that we're serving our clients? If our clients are showing a pattern of discrimination, either blatant or other, that's on us as an agency. Like we're going along for that ride, right?
Yeah. So I mean, if the client has a pattern of discrimination, in other words, if you are serving a light industrial site and you send qualified candidates, regardless of what they look like or their background, to the client, let's say, for example, you send a bunch of pregnant women and you notice that the pregnant women are all immediately sent home each and every time you do that. And you can exchange pregnant women for anybody else in a protected class.
Right.
Then your client is potentially discriminating against folks based on that protected characteristic. And the law is pretty clear that the staffing agency is liable for that decision if you knew or should have known of the conduct and didn't take action. And if you look, the EEOC published guidance on this a number of years ago, and they don't really fully understand the staffing industry. But I mean, one of the things they say is that if you then address that issue with the client and they refuse to address it or take any kind of corrective action, then the staffing company should stop doing business with that client. Now, if it's a multi-million-dollar client, I don't know how realistic that's actually going to be, but that's what the government's position is. So taking that now into the pay transparency perspective, again, there's a difference between pay transparency and pay equity. The pay transparency laws merely require you to publish the range. The question, though, is what are plaintiffs' lawyers and employees going to do once they have that information? And that's where the pay equity concern comes into play, because they may take the position that, oh, that's very interesting. The range is, $9 to 24. How come only the minorities and the women are at $9? How come the white men are at the higher range? And you need to be able to explain that under one of the various factors that fall under the exceptions of the pay equity law, one of which is it's based on a factor other than sex. And that's what I'm saying, that I think our position in many of those cases would be that your contract with your client, which is an arm's length transaction, is a factor other than sex. And if our client is paying us, $12 an hour for an employee, we can't pay that employee $15 an hour, right? That doesn't make, right? We probably can't even pay them $9.50, right?
Right. Yeah. That's where I was going with that, with my mind. I'm like, it's time to fire that client just on the grounds of poor economic principles. Forget about the legal side. But
that's right. But then there's another issue here. So one of the problems for the staffing industry that the pay transparency laws have is that if you are working in a market or an industry where the markup is generally standard, like let's say you're working in a industry in a area of the country where the markup is a standard 33%, okay, and might be higher, might be lower. You
should always use 50%. It's the easiest math for any example that you use. And
fair enough.
It's just
all
good.
right.
It's
Dan
good
has corrected me.
Universe.
Dan has corrected me. We're going 50% margin,
All right.
folks.
Perfect.
So, if your normal pay is, let's say, $15 an hour. So now I used an odd number. I should have used an even number. I
2250.
just screwed up the example, right?
2250.
There you go. This is why lawyers don't do math. So yeah, so 2250. Well, let's just use an easier example. Let's say it's $10 an hour, right? Let's make it real basic. $10 an hour is what you usually pay. So they know that the markup, you're charging your client $15 an hour. Well, that means all your competitors will know what your client contract is. Because if you post an ad for $10, they're going to know your client contract is, oh, they're getting $15 an hour. Let's undercut them and propose $14.50. And so what some staffing companies might try to do to get around that is, instead of saying that the range is, $9 to $11 an hour, we're going to say it's $9 to $20 an hour, because now our competitors are going to think, oh, it's $20. That means the contract's 30. So to undercut them, we'll come in at 29. Lo and behold, you're really at 15. But the problem is that range is not grounded in reality. And so it creates some of those same legal issues and employee relations concerns that we discussed before. So a little bit of a yin and yang there in terms of how much risk you want to have out there versus information that your competitors may get a hold of.
So that's actually interesting. So I hadn't actually thought about that angle, honestly, of that when you put your pay transparency out there, that your competitors could basically look at this and reverse engineer. That's an interesting approach. So let me ask this question. Let's say you're a staffing agency and you're headquartered in a city and state that is not currently governed by pay transparency laws, right? Because they're not federal, they're kind of localized at this point. And you're recruiting for a client that is also not in an area that's governed by pay transparency laws at the moment, but they're recruiting for someone to work in a city that is governed by it, and you're recruiting in that city. So do you have to publish the pay range and be compliant with pay transparency because the work is being done in a city that it's governed? Or can you say, no, I don't need to post it because I'm operating out of an area that's not governed, or